Right, well, thank you, Claire, and thank you, everybody, for remaining with us. As per usual, I've got the last lap to do before lunchtime. We are running really well to time, actually, at the moment, so we should be fine for my section, and then the opportunity as well for any Q&A at the end before we do go into lunch. I appreciate that some of you will probably have more sensitive questions or prefer to speak to us confidentially or on a one-to-one, and that's absolutely fine, and we will be here during lunch and afterwards to facilitate that as well as any follow-up after the event. So thank you very much. Let's do the case law update. Obviously, Claire's covered an awful lot of case law in terms of discrimination, but there are, of course, a lot of other cases. So I've just picked out some of the key ones to take you through to sort of talk about some of the interesting things that we've seen coming to light and happening and what that means for you as businesses as well. So the unpaid holiday case. First of all, Smith and Pimlico Plumbers, we've heard that bandied around such a lot because it is a landmark case. In terms of where we're up to with this and what it means, though, the Court of Appeal handed down a significant judgment in February of this year on the payment of historic holiday pay claims. Importantly, of course, in the previous ruling on this case, the Supreme Court determined that the claimant was a worker, not self-employed. So if you remember that this has been backwards and forwards, and that was the sort of key ruling at that time. So the Court of Appeal landmark ruling held workers were incorrectly classified as independent workers can then claim back unpaid holiday for the whole period of engagement. So that's where we're up to with this case. So it's overturning the previous EAT position where the claim had to be made within 3 months of that holiday period. So remembering now then that workers are entitled to claim national minimum wage, SSP, statutory paid annual leave of 5.6 weeks per year, and that is then for the whole period, so it can be claimed back over the whole of the period that they've worked for. So undoubtedly this has a significant impact on the whole sort of gig economy. So very important to correctly go back and determine employment status. So if you've got doubt about independent contractors within your business, please go back and have a look at that. I mean, not only have we got the whole IR35 issues, but we've also got this now as well in terms of how significant that could be and costly. Importantly, it doesn't change a business's policies on carryover rules in your contracts. But I think it does stress the importance of having very clear, up-to-date policies and contracts regarding holiday. So it is an important one to highlight this morning, undoubtedly. And this case, was it just a prank? Well, in this case, the claimant was a technical product manager and known within the organisation. I think, we've always got to look at the facts, haven't we, of the individual cases. So he was known within the workplace as being a practical joker. On this one occasion, he thought it would be quite funny. Goodness knows what goes on in these people's heads. But anyway, he thought it would be quite funny to set up lines of sherbet powder along his desk with little rolled up pieces of paper alongside it so that it looked like he'd been taking drugs. I mean, seriously. Anyway, he did it, and then not only did he do that, but he forgot about it. So he left it there. He forgot about the prank, walked off, and what actually happened was the external cleaners came in to clean up after him and obviously looked at this with some concern. So took it to one of the managers who then looked at it and thought, oh, well, he is a prankster, but then doubted themselves and thought, actually, is it drugs? Is that drugs in the workplace? So reported it to the directors. What happened was, of course, the company then started disciplinary proceedings against the claimant, and they actually found him, as part of their process, as guilty of gross misconduct. They concluded that basically he could have brought the company into disrepute. If people were going, these were external cleaners, if they were going externally and saying, there's a drug culture there, we found this. And they said also it could have been something quite big on social media. So they relied on those two factors in terms of the termination. Actually, when this did go to tribunal, the judge took a more sort of pragmatic view and said, actually, this silly prank wasn't really enough to warrant a gross misconduct termination. He took the sort of view that the cleaners knew really it was a prank. They'd reported it because it didn't look good. It didn't actually go into social media as far as everybody was aware, and if there were to be any comments across the workplace, everybody knew he was a prankster, and that's what they were saying. So those are really quite important points in terms of the fact that he was then found to have been unfairly dismissed. Other relevant factors, because like I say, we always have to look at what else the tribunal considers. He got 14 years service. He got a clean disciplinary record apart from one past warning that had been spent about saying something disrespectful, probably another prank in the workplace. So it is quite important to look at those facts, because you can see, of course, why the company came to the conclusion that they did in terms of dismissing him, but also there were other considerations they should have thought about, including, could he have been given a lesser sanction for that? Was it really gross misconduct? So, interesting. And like I say, I don't know what possesses people to do it, but they do, and they keep us in business. So, so happy days. Okay, so this next one, Cabelius and Kent Foods. Again, fairly interesting and arising out of the pandemic period. So this claimant was a delivery driver. And he was actually driving his wagon on a daily basis to the Tate & Lyle premises. Tate & Lyle were a major client of the company Kent Foods. So he's in and out in his truck, and he's waiting on the premises in his truck. He's actually inside, windows closed, and he wasn't wearing a face mask. He sat there, and two of the managers came out to him, banged on the window and said to him, actually it's policy, you need to wear your face mask whenever you're on our grounds. He refused to wear it. He said, I'm in my truck, I'm not wearing it, I'm not outside, I'm not mixing with anybody. Interestingly as well, at that time, it wasn't obligatory to actually wear face masks. Face masks were optional in terms of government guidance. But, and this is the important bit, Tate & Lyle had got a very strict policy, a clear written policy that everybody was provided with, including those suppliers coming onto their premises, that any time, that whether in trucks or wherever they were on the premises, they needed to wear face masks. So Tate & Lyle barred the claimant and reported him to his employers, saying that he had actually failed to follow their policies, and therefore he wasn't welcome on their premises anymore. There was a disciplinary process, and in this situation, that driver was dismissed for gross misconduct, for failing to adhere to policy and the driver's handbook. He brought an unfair dismissal claim because his view was, this is ridiculous. I'm sitting in a truck, what do I need to wear a face mask for? But again, there is always an important outcome to these cases. And in this case, the judge believed the employer had acted fairly. They said, the policies couldn't have been any clearer. And whatever this driver's view was on it, he was on their premises, and that policy was very clear. And also it had, of course, a significant impact on the relationship between the supplier and Tate & Lyle being their major client. So important points. There was a fair investigation. He was given a fair conclusion. They viewed them as genuinely viewing him as being, acting gross misconduct in that situation. Next case. Okay, so another delivery driver, this one for Domino's pizzas. This claimant was working at the time during the pandemic, and in March 2020, he wrote an email to the HR team at Dominos saying that he wasn't coming into work until the Prime Minister said that it was safe to do so. He went on to say that Dominos was absolutely not essential, and he was not going to put his life at risk in a lockdown. I actually think my son would have a very different view of that. I've looked at my Just Eat account, and I know how many Domino's pizzas come in and out of our house. So anyway, whether he is right or wrong in that point, that is what he says. It's not essential, so he's not coming in. HR actually responded in a measured way to this and said there's actually no need for him to then attend the workplace if he felt like that, provided he filled in a self-isolation form. That wasn't good enough for the claimant. The claimant then went on to put various messages, scathing remarks on Facebook, including quite an abusive remark to colleagues who were actually continuing to work for Dominos. So, perhaps not surprisingly, the claimant was dismissed by the company at that point for gross misconduct, relying on a breach of social media policy, posts that were detrimental to the business, and also threatening behaviour towards other members of staff. The claimant then said, well, actually, this is all to do with health and safety measures during the pandemic and my beliefs, so I consider that this is a protected disclosure in respect of health and safety measures. So the judge considered that, but said no, in these circumstances, this could not possibly be a qualifying protected disclosure, albeit that he was relying on health and safety, because clearly the three measures clearly considered by the company in reaching their conclusion were very fair and accurate. It was a breach of those policies, and the threatening behaviour to the employee as well was, of course, gross misconduct. So a fair termination there. In Gibson and Lothian, this claimant was employed as a chef, and this is again during this period of pandemic. So he was put on furlough under a furlough agreement in March 2020. During the furlough, and in the run-up to lockdown, the claimant voiced various concerns about a lack of safe working measures and practices and a lack of PPE, and the possibility of, given their conduct, that his father could then catch COVID because he wasn't being adequately protected in the workplace. The claimant then believed this to be very negatively taken by the respondent when the respondent just turned around to him and said, "Shut up and get on with it, would you?" So, following that, he was obviously quite upset with the respondent's behaviour, and the respondent started a process to make the claimant redundant. Their process was to send him a text message, so that was how they concluded this. In this situation, the claimant obviously brought a claim, and he was found to have been automatically unfairly dismissed. Because he had taken appropriate measures. So again, the facts of these are important as how you apply it to the workplace. He'd taken appropriate measures to bring sincere and genuine health and safety concerns to the employer's attention. And he was clearly only chosen for redundancy based on doing this, plus, of course, no fair process and a text message to terminate somebody's employment, even during the pandemic when people weren't necessarily face-to-face at all times, was not at all appropriate. So clear policies and procedures needed. That certainly stresses this to be the case. In the Hundley case, this claimant was a full-time flying instructor. And again, during the pandemic, April 2020, he was placed on furlough again. And this furlough scheme, there was an agreement in place saying that it would be for up to a period of 3 weeks or until he could return to work as normal. The respondent during this period decided it needed to then consider redundancy due to the significant impact of COVID, and the flight school was struggling. They didn't need flying instructors to the same capacity, and finances were clearly dipping. So they started a redundancy process, and the claimant was going to be made redundant in August 2020. This was then questioned by the claimant, who said, but hold on, you've put me on furlough for this period, so why are you not continuing furlough and making me redundant? In this case, the tribunal disagreed with the claimant. They said that whilst in different circumstances another employer may have taken a different approach, because there was the furlough scheme still in place, but they said that it was not unfair during this period to make the respondent redundant based on the fact that there was a declining workload, finances clearly were significantly struggling. So they said, provided there was a fair redundancy process, then this was entirely fair to reach that outcome. And I bring that case to your attention because it's actually in contrast to the next case, which also is a case at the time of furlough, arising out of the furlough situation. So in this case, the tribunal found that the claimant was unfairly dismissed when the employer refused to consider furlough. So slightly different facts, because in the case previously, furlough of course had been considered and used, And then obviously the company had looked at their situation and decided, actually, we need to make redundancies. In this case, furlough hadn't even been considered. The tribunal accepted that in this situation there was a genuine redundancy situation, but they said the whole purpose of the furlough scheme was there to avoid redundancies. So what this comes down to is this company hadn't even given it any consideration. So in this case, it's not necessarily unfair to make an employee redundant, was the outcome, but you've got to have exhausted, of course, the furlough scheme, and well, in terms of considering it and how it would apply in that situation to mitigate the need to make redundancies. So 2 different outcomes, but on slightly different facts. If we look now at this remote working case, this is actually an Irish case, but of course the factual circumstance is still very relevant to everything that goes on in England and Wales as well. Here an employee was found to be constructively unfairly dismissed after her employer refused her remote working request. This was despite raising concerns about safe working and the fact that if she was working in the workplace, she could catch COVID and pass it to her asthmatic husband. The respondent was criticised for not even trialling this remote working arrangement. So again, we are now in very much an environment of hybrid working, remote working. And so this case really stresses that, a failure to give it any sort of consideration is just not acceptable. Obvious pointers to take away from that. We are in a very different world now in terms of the working arrangements that we need to consider. So whilst flexible working isn't guaranteed, because it depends what the needs are in your workplace, it has to be given some consideration. And of course, trialling an arrangement, particularly where there are concerns over health and safety, is really a must. Trialling something, if it doesn't work, then you can always go back and say it doesn't work, and you will have acted fairly then as an employer. And again, flowing on from that, flexible working. This case, though, really is about where an employee had not agreed to an extension to the normal 3-month time for deciding a flexible working request. I won't go into all of the details on this because it's probably a bit laborious in terms of the facts of the case. But what I would take away from this case is the fact that, there is a clear flexible working process, the statutory minimum that you need to comply with as an employer. And in terms of any extensions to those time frames to consider flexible working, if it is mutually agreed, and I think this is the point to take away, if you've agreed an extension with that employee to carefully consider it or look at how something might work in the workplace and take a little longer over your decision making, maybe you've got to consider whether somebody else could work back to back with that person. Make sure that's in writing. So make sure you have got that mutual agreement in writing, because this case very much turns on the fact that there wasn't actually anything in writing to show that there had been an agreement to that extension. So perhaps a more interesting case. In this case, an emotional affair, whatever that might be, but the claimant, importantly, was a head teacher and also the head safeguarding officer at this primary school. During his employment with the primary school, he entered into what has been deemed an emotional affair. I mean, it is not said in anywhere to be a sexual affair, but emotional. And this was with a parent and led on to an emotional relationship with her children. So this was even after the deputy head and also the deputy safeguarding officer had raised concerns with the claimant, saying to him that he was placing himself in a vulnerable position with the parent, by helping the children and by being seen so much in the office with the children, it wasn't looking appropriate. So he was given lots of opportunities to try to put this right. And of course, it then got back to the governors. And the school brought disciplinary proceedings and the police were involved. As I've said, there's no actual evidence of sexual or untoward behaviour here. But there was a very close emotional involvement with the parent and the children, and this was viewed as being a breach of the safeguarding policies. This individual was dismissed on the basis of it was a complete breach of his safeguarding duties, and he brought a claim of unfair dismissal because he didn't feel he'd done anything wrong. He felt he was looking after the parent and the children, and that was part of his duties. In the judgment, it was held that the school had been right in their actions, although there wasn't any evidence of any sort of improper behaviour. It was just not correct behaviour for somebody in that position of trust. And they went back to look very closely at what the safeguarding policies said. So again, the stress is on, your safeguarding policies or policies being really clearly written so that those people who are being disciplined, those employees who are being disciplined, are accountable. They need to be trained, they need to understand, and in this case, this claimant certainly had been and was aware of his obligations. Working time and national minimum wage. This was the long-awaited decision on sleep-in worker pay handed down in March 2021. So this confirmed that residential care workers who sleep in are not entitled to national minimum wage for time that is not spent awake performing duties or specific activities. So in this Tomlinson-Blake case, Mrs. Tomlinson-Blake didn't actually have to carry out any duties whilst she was on this sleep-in. Although she did say that she offered a sort of listening ear just in case anything happened, but she did expect for that period to be paid the national minimum wage, so she brought a claim when she wasn't. Her claim was initially successful in the ET, determining that she was entitled to be paid for all hours while sleeping in, which were held to be working time for, of course, national minimum wage calculations. The Employment Appeal Tribunal then went on to support this decision, but on a further appeal from MEMCAP, as you will all know, the Court of Appeal overturned it, and it is really a landmark judgment here. The Supreme Court has now followed the Court of Appeal's judgment, and so accordingly, sleeping in is not it is not to be paid a national minimum wage. It's not classed as working time, where workers are not having to carry out, like I say, actual work or project work. So if they're just sleeping and they're maybe offering a listening ear, that's not sufficient. But if they are having to get up and actually attend to anybody there or carry out any other sort of work, then national minimum wage would apply. Okay. In this situation, an inadequate investigation, the tribunal ruled that the claimant, who had worked as a caretaker, had been unfairly dismissed by the respondent on the basis that an investigation was not fair or conducted in any way reasonably. And this was given the size, and again, these are the facts, the size and administrative resources of a large supermarket chain. So it was held that, because they've got such resource, there is that extra obligation on them to carry out a really thorough and conclude on their investigations. In this case, the claimant was actually alleged, amongst other things, to have shown off his swastika tattoo to a new starter, and then he went on to assault another employee by running into them with a trolley. He was dismissed for gross misconduct, but as I've said, the importance of this case is making sure that a thorough investigation is carried out. The tribunal found that the claimant had been unfairly dismissed. They said also, despite the fact that it was very clear, yes, that the tattoo was not the Buddhist symbol of peace that he was trying to say it was, it clearly was a swastika, a Nazi swastika. But, that aside, that's not the point. The fact that a thorough investigation wasn't carried out in line with their own policies and procedures meant that dismissal was unfair. In this case, vicarious liability, and we are coming to the end of the cases now, because in fact this is my last one actually in mopping up. This employer was found not to be liable for workplace horseplay after a practical joke in the workplace went wrong. Looking at the facts, Mr. Shell was employed by, he was employed by Tarmac. He was employed by Roltec Engineering, and he was contracted to work for Tarmac. He was working on the Tarmac premises, and one of the employees went into the workshop with him, and as the claimant, Mr. Shell, bent down, this other employee struck 2 pellet targets with a hammer. Now, I'm presuming that means that they sort of erupt and it makes some dreadful noise, because the claimant's ears ended up with a hearing impairment, and he had long-term tinnitus as a result of that employee's conduct, which, hadn't been done with any malice. It had been done as a practical joke, but it went wrong. The tribunals looked at where the equipment came from. The hammer was supplied by Tarmac, and the employee had brought in these pellets of his own volition. The claimant said in his case here that Tarmac were vicariously liable for the damage caused to him. But in light of their own policies, procedures, and the fact that this was so tenuous, i.e., there was a hammer there, but nobody could have expected this employee to bring in pellets and start banging them so that there was that sort of noise. Tarmac were held not to be vicariously liable, but again stressing the importance of clear policies and procedures and training staff on behaviours in the workplace, because they relied on all of that in getting themselves out of that vicarious liability position. And that's really our sort of mop up on the cases, and I've just really got a few forthcoming changes to look at with you. There's been so much going on in terms of COVID, Brexit. We've obviously got the situation with Russia. So the government, I would say, is very preoccupied at the moment. So it's not as long-winded as it perhaps normally would be in respect of things to look forward to. Maybe on a high, though, the government announcing last year that for the Queen's Platinum Jubilee, there's going to be that additional public holiday on Friday, the 3rd of June. So creating a 4-day weekend for us all, moving the May bank holiday, isn't it, to Thursday, the 2nd of June. So that's how that's all going to work. But if we just look at a few pointers there in terms of what this means, remembering whether a worker can be required to work a public holiday is, of course, a matter for the contract and the needs of the business. So we need to go back to the contractual entitlements here as well. Full-time workers getting 5.6 weeks statutory annual leave. Most businesses close during bank holidays, so it may require employees to allocate holiday to cover this period. As I've said, it depends what is set out in the contracts and what you do by custom and practice. But certainly, some of the issues arising, there is no statutory right to take time off. So although we've got a 4-day weekend being advertised, there isn't actually this statutory right. On the public bank holiday. And also, employers are not required to provide that additional paid leave, although, of course, given how this has been advertised, it is going to be expected. So you've got to bear in mind staff morale alongside what it says in your contract as well. Employers, of course, can ask staff to use existing holiday entitlement to cover the June public holiday. But just a reminder that if that is going to be something that you're going to do, you need to give notice. So remember, for the holiday that you're requiring them to take, you have to give double the amount of notice. So for 2 days holiday, you'll be giving 4 days notice if that is how you want to address it. So just a few things arising out of that whilst we all celebrate that we've got that extra holiday to enjoy. The employment bill, I mean, we did touch upon this briefly in the last roadshow as well, and we could see this come in this year. I mean, like I say, there's an awful lot going on, isn't there, for the government to deal with, but this certainly is reasonably imminent in terms of the proposals and what we have seen in the bill. So, what does it cover? I mean, we've got flexible working requests can be made from day one, not after 26 weeks. We've got the right for workers to request a more predictable and stable contract. We're talking about casual staff, 0-hour employees. So, those are contracts where they want to see a more predictable and stable contract, and they could be requested after 26 weeks, so the after 26 weeks is relevant there, provided this all comes in as drafted. Tips and service charges to go to workers in full. Okay, so nothing to be taken from by the companies, that has to go to the employees or workers. Leave for neonatal care, so supporting parents of premature and sick babies, some new guidelines to come in there. Also leave for unpaid carers as well. And extending redundancy protection during maternity leave. So currently, employees have priority for alternative employment if made redundant or part of a redundancy process during the maternity leave period. But this new legislation would mean that the employee would be covered from when they notify their employer of the pregnancy until 6 months after the end of the maternity leave. So a few important changes due to come in there. The post office scandal, this stricter rules on workplace surveillance. This is very much being pushed at the moment by the Trade Unions Congress, the TUC, which of course represents a massive 5.5 million members from 45 unions in England and Wales. And this has all come about after 700 sub-postmasters were wrongly prosecuted for theft and fraud, livelihoods were ruined, some went to jail, and this was all about workplace surveillance and automated decision-making. So the TUC are obviously wanting technology to be, wherever anybody is introducing workplace surveillance, for them to be consulted so that they have a proper understanding of how that is going to apply and how decision-making will flow from that because of the consequences that have been seen. We've got some other government consultations that are ongoing at the moment. So the modern slavery reforms, proposed changes to modern slavery statements. And just to give you a little bit of flavour on that, organisations needing to include in their modern slavery statements such things as the organisational structure, supply chains, policies that they've got relating to human trafficking, due diligence in relation to slavery and human trafficking, and how it's being managed and the effectiveness within that workplace and business, training and capacity building. So there's lots of guidance around this, and I would say that if you haven't considered updating your policies on this, it is something very much to consider at the moment with the likelihood of that coming in. And non-compete clauses as well. Consultation closed on the ban on exclusivity clauses for low-paid employees, and this specifically applying at the moment to workers where the weekly income is less than lower earnings. So at the moment, that's £120 per week, and that's really to enable them to seek alternative work. Otherwise, they're obviously not earning what they could be with that non-compete clause in force. Okay then, and national minimum wage. So where we're seeing some increases, new rates from the 1st of April 2022. So national living wage, 23 years plus, is going up to £9.50. National minimum wage for 21 to 22-year-olds is then £9.18. And on to the next slide. We've got 18 to 20-year-olds going up to £6.81, 16 to 18, £4.81. And of course, the apprentice wages as well will also see an increase from £4.30 to £4.81 as well. The annual increase on compensation limits in the tribunal. So for unfair dismissal, a week's pay, the basic award or redundancy payment, will increase from £544 to £571, with the maximum compensatory award going up from £89,493 to £93,837. And these are coming in on the 6th of April 2022.